Great. Thank you. So our two speakers today are Arden Levy and Ruth Kochenderfer. Arden has a specialty practice, which she's had for the past 10 years in Arden Levy Law, where she focuses on helping companies and individuals secure substantial amounts of dollars in coverage in white collar and other matters. She started her legal career in the Army JAG Corps, and then followed by 10 years of experience in big law at Howry doing white collar and insurance recovery work, and then started her own practice. And so she has a lot of experience in this area and a lot of good tips to share for those of us who are participating in the Zoom today. And Ruth is managing director at global insurance broker Marsh. She's co-leader of Marsh's healthcare management liability practice. And before that, for I believe 17 years, was at Steptoe and Johnson, where she represented insurers in insurance disputes. And so Ruth brings a perspective from the other side, for the insurance side, and again has a lot of useful insights. So without further ado, I think we'll get the presentation underway. And one of the things that came about when we were preparing for the panel was my question of what the practical tips Arden and Ruth can share with us when we first get involved in a matter. What should we do? What are the insurance considerations? So I think that's how we're going to start today.
Andy?
Yes, ma'am.
Andy?
Oh.
Can I ask you a question?
Yeah.
So I
think-
put in chocolate chip scones for you, but they weren't done. Do you mind taking them out? in a few minutes?
Carolyn, can you mute yourself?
Okay.
We're all working
If
moms.
everyone could go on mute.
What?
Great.
I got her.
Perfect.
All right. Well, as we all know, we're all working moms, and I assure you, I have on the same professional outfit all the way down to my shoes that you have today. Anyway, so thanks for the introduction, Lisa. I am Ruth Kochenderfer. I am with Marsh. One thing I do want to make clear, I used to represent insurers at Marsh. I now represent policyholders. So I can say I've worked on both sides of the V, so to speak. So it's been, very eye-opening, and hopefully I bring that balance. But as Lisa talked about, we really do want to make this a practical. I don't know how engaging it will be, because at the end of the day, it's insurance, right? So, but we do really want to make it practical for you. We would love to have, a dialogue with you. And if you have like pressing questions or even some kind of current matter, you have a question, we would love to be able to kind of just engage in that with you. I spend a lot of my time doing that as a broker. But really, this slide is to kind of talk about what do we want to do? What if you take away 2 or 3 things today from this webinar, this is really what we want you to take away today. And the first and foremost is think about insurance. When you get that first phone call in, please think about insurance. And why am I telling you to think about insurance? Because if there's any insurance that could be out there to pay for those defense costs, or hopefully never needed, but for any type of settlement or judgment, you need to notify them immediately, because failing to do that, and we'll talk about that, can have some very dire consequences if you don't do that in a timely manner. And then you also need to make sure that if there is insurance out there, you're doing everything that you need to do to make sure that you're getting paid as that attorney, and your client and the insured is getting the benefit of that insurance that's been bought either by them or for their behalf. So that's our goals for today, insurance.
Yeah, thanks, Ruth, and thank you to Lisa and the group for inviting us to speak. Really glad to be here. As Ruth said, sometimes just even the word insurance can make people feel like they're ready to take a nap, but it can be really important stuff. And I know that when I worked with defense counsel, and there's an initial, and whether it's a coverage denial or an issue with payment or rates, when we're done with the matter and when we sort of negotiated and worked on continuing to be reimbursed for the defense costs, you know, some of the defense counsel I work with will say, I didn't realize it, but you're my best friend because you make sure that, you know, we get paid. So, you know, as you know, Ruth said, when you do get that first phone call, whether you're representing an individual or you're representing an entity, you really do want to be thinking about insurance right away. And so our practice tip at the bottom here of slide 3 is, you know, particularly if you're representing an individual, that the first thing that you want to be doing is gathering the insurance documents, requesting a copy of all potentially applicable insurance policies, and you know, whether there's looking at if there's an indemnification agreement between the entity and the individuals. So you want to be gathering information, you want to be evaluating insurance right away. So here are some of the key triggers that can one lead to, you know, you being called and your retainer, but the events at the same time that also are triggering potential coverage. So the first is it could be as simple as a knock at the door or a phone call asking for an interview. It could be a letter indicating or notifying that an individual is a target, and it can be any level of investigation, a subpoena, a civil investigative demand. So anything where the government is interested in investigating your client or interviewing your client. And as counsel for individuals, right, some of the first issues that you're going to have often actually the insurance event that comes into play is the retainer of counsel, which really usually happens before insurance counsel comes in, because counsel will be retained, you know, whether it's an individual or it's an entity. Often these are, you know, whether it's, you know, bet an individual's career or potential criminal liability, or an entity as well. So skimping on, you know, people are looking for the best attorney, the best fit for them. And so making sure that there's going to be coverage for the selected counsel, particularly where insurance policies, for example, have panel counsel, and individual counsels may not be, you know, listed on that. And so you'll want to immediately be negotiating with or coordinating with the individual's counsel. You might be working through the entity, but still you also may even be working directly with the insurance company. It may depend on the situation. And then also the defense rates and securing the more something as close as possible to the actual rate. You know, I've had insurance companies be interested in these types of investigations in paying, you know, starting offers of $185 in the DC area, which, you know, it's an absurd offer, right? Even the Laffey matrix, I think, is, you know, high 400s, low 500s now for a counsel who's been practicing for 20 or more years. And so immediately negotiating those rates is very important. And then also there may be issues with the entity seeking to get some kind of undertaking or other agreement where the entity can limit its coverage or its indemnification of the individual, and thus payment of those defense costs. And so evaluating that under any kind of undertaking agreement like that is maybe as important. And so counsel, you know, coverage counsel or your defense counsel, as defense counsel, will want to be looking at what the policy states that it covers in tandem with those undertaking agreements. And then the events that potentially raise insurance considerations, of course, could sort of run the spectrum from beginning to end, because even if coverage is secured, whether it's the entities paying or the insurer is paying, the defense, reimbursing the defense costs directly or paying the defense costs, then there can be an issue where, well, what if there's an indictment? What happens then? And so, so even if insurance is negotiated and seems to be going smoothly, it's something that throughout the course, the lifetime of the matter is something that you'll want to be watching to ensure payment of defense counsel.
I would add just on this is not an exclusive list of things that could potentially trigger insurance coverage. An email from a government entity. We've had many of those, an email from an attorney, a demand to toll a statute of limitations, any type of ADR demand, anything that there's so many things that could trigger the potential for insurance getting involved. So think broadly. So don't just think, oh, I need something formal. I need a complaint. I need someone demanding. It doesn't have to be that. So unfortunately, I have a lot of clients that get tripped up by that. And we're going to talk about the consequences of getting something like that and not telling the insurer in a few slides in. And the other thing I would say here is that I know some of you represent individuals and some of you represent entities. Coverage for individuals is generally going to be much broader, especially for investigations, than what we are for the entity. I would say that just in general under these policies. So if you are being contacted with someone and someone says, hey, there's no coverage, you might want to poke that a bit and say, when you say no coverage, is that because the company's not coverage? Have you really looked at it for the individual? Don't take somebody's word for it. Back to Arden's kind of first practical tip, to the extent you can, get a copy of the insurance policy. I am a broker, and I'll be the first to tell you, I tell my clients to give their policies to no one. So there is that kind of tension. It's one thing for them to give it to an insured, but even if you can't get the full policy, talk to someone like Arden and say, okay, if I can't get the full policy, I at least need the definition of certain key terms to figure out, whether or not there may be coverage. But it's all that. Don't just assume because someone said, oh, there's no insurance involved, we should stop there. So with that, let's talk a little bit about the next slide. Coverage for entities. Arden, you want me to start and then you weigh in?
Yeah, and then
weigh in. So we're going to talk even more about notice, but coverage for entities, notice is always, there's a lot of overlap here, right? I did just say it's typically a narrower coverage, but narrower doesn't mean that there's not a lot of overlap in many of the same things that could trigger coverage for an individual under an insurance policy. Could also trigger coverage for an entity under the insurance policy. So it's kind of the same advice. Once again, I think you're going to hear a theme: think about insurance and notify insurance. It happens to be a theme, even as a broker, that I tell my most sophisticated clients who have large risk management departments. We still have a lot of issues about making sure insurance is brought in early. Therefore, you can get the full benefit of that insurance. But, we're going to talk about even some more of these types of things and some of the issues. Some of the things we have on here. Notice is really, for some lines of coverage, notice is the #1 reason for denial of claims. That's why I cannot stress how important getting the notice right is. And when I mean, and it's notice, I'm not talking about fancy, it's late notice, timeliness of the notice. Pretty simple thing. Very, very frustrating as a broker to have something that arguably simple be a basis for losing access to a lot of coverage. I suspect Arden would have a similar view on that. So, that's going to be my kind of one beef from this. So with that, Arden, anything else?
Yeah, just to, for when you're counsel for entities, the range of when coverage can be triggered really can span many different events. So we'll be talking a little bit about some differences between insurance, D&O policies, directors and officers policies for private companies versus public companies, because there are some notable differences there. But sometimes what I find when I first get brought into a matter is that whether it's the client or the defense counsel will have looked at the main section of a policy and sort of given a cursory glance at endorsements. And I have found that particularly in in every arena. First of all, the number one rule is to read the policy. When you're an associate in a big law firm and you start insurance coverage, it's the first rule that takes about a year of, did you read the policy, in detail? Every word matters, like every contract. And often changes to coverage or additional coverages are going to be found in the endorsements as they're read in tandem with the entire policy. And so, an example is that there may be coverage in the policy, the main body of the policy itself, that appears to only be where coverage might only be triggered, for example, when a complaint is served, which, as you can see kind of in the timeline of investigations, is really at the end of once you get to a complaint, you're often far down the line, hundreds of thousands to millions of dollars into defense costs. So you really want to be looking at what is the wording, when is coverage triggered, and for example, it may be that there's entity government investigation coverage that has sublimits to it, and you'll of course want to be aware of those sublimits. That being said, if you're counsel for an individual, often that coverage, as Ruth said, is broader, and so often there will be different or higher sublimits that apply to coverage for individuals versus entities. My practice tip for the range of events is sometimes I'll find when I get brought into a matter is that from the get-go, particularly entity counsel or is trying to minimize the publicity, the public eye damage, and so they are interested in not having a subpoena and just receiving an informal request for documents or information. And that's the kind of decision that I would encourage you to consider in the context of insurance, because it may be that coverage is only triggered if there's a subpoena, whereas if there's an informal request, there isn't coverage. And so those are each of these events all the way down the line is going to be important for determining when or whether coverage might be triggered.
All right.
I love this slide.
I'm glad you like it. I'm going to do full disclosure here. I was not a management liability lawyer, doing D&O before I joined Marsh about 8 years ago. And I did not, if you don't do this every day as an insurance coverage lawyer, this is not the stuff that I knew. So I learned about this stuff at Marsh. But this is a really basic structure of a D&O policy. And why do we have it up here? Because it really shows in a kind of graphic way the difference of coverage between how you kind of enter into the various coverages available in a D&O policy. So there's kind of 3 parts of a D&O policy, and it's very basic. A, B, and C. That's literally most of the time how the insurers refer to it. It's A, B, and C. We're going to go in reversed order. It actually makes sense. Side C is coverage for the entity, right? That's for the entity itself. As we've already hinted at, it's typically a little bit narrow. It's typically narrower coverage than it would be for the individuals. And there's even a big significant difference between publicly traded companies and private and not-for-profit companies when it comes to this side C coverage. We're going to talk about that in a slide or two. But side C is for the corporate entity, always subject to a retention, or I should say deductible, right? Almost the same thing. It can be very high for larger companies, maybe a lower amount for small, but that's side C coverage, the entity coverage. Side B coverage is when the corporation indemnifies the individual. Could be a director, an officer, or an employee, and some other, it can be an independent contractor sometimes, it can be a leased employee sometimes, there's various ways. But it's when that indemnity obligation kicks in and the corporation's doing what it's doing under its bylaws or otherwise under the law with respect to its indemnity obligation. Maybe ties back to that undertaking agreement, right? The scope of that. But this is also subject to a retention or a deductible, because it's assuming the corporation can pay. What's really, really valuable for individuals is something called Side A coverage. Side A coverage is when the company cannot or will not indemnify. So the most likely cannot is insolvency or bankruptcy, right? They don't have the money to pay. That is a big trigger for Side A. Will not, it could be the situation where the company, everyone perhaps thinks they should be indemnifying and they just aren't. Or sometimes when we are involved in some of these more recent sexual harassment issues, sexual assault issues, where the corporation has said, you violated our bylaws, we don't have an indemnity obligation or things of that nature. There are, other types of legal prohibitions against perhaps corporate indemnity. Side A insurance kicks in. Why is that important? No deductible. Side A never has a deductible because it's meant to protect, you can see at the bottom, the personal assets of the individual, right? It's meant to be $1 insurance. On top of that, even within a D&O policy, Side A coverage is much broader than what's available for the Side C, the corporate entity, or even when the corporation's being indemnified, because once again, it's out to protect individuals. We'll talk about it again, but in addition to being all this in one policy, there are Side A only policies, which are out there. Many companies buy them, both public and private, not-for-profit, especially in the public arena. So another practice tip, don't just get the primary D&O policy. Ask them if they have a primary Side A policy, because you want to see that wording too, because that wording is different than what your primary D&O policy is. And that may be for those representing individuals, you may need that at some point, right? If the corporation stops doing what you think it should be doing with respect to indemnity, and you're looking for a way to get your client protected and your attorney's fees paid. So,
And Ruth and Arden, is your recommendation, I mean, it's a little, for those of us who mostly represent individuals, it is a little bit awkward. You've just been referred a case. Obviously, you're very grateful for the referral and look forward to working with your colleagues representing the company. But is it your, in terms of practice tips, that I think we discussed this in yesterday, that it is best if you can figure out a way to politely request either the policy or just the Side A language itself at the outset, before things get contentious and before there might be a divergence of interest, that's your recommendation?
if you can get it, absolutely, right? Because, and you can even do it in a positive way. Hey, we want to make sure that, any insurance is out there. We'll help you work to make sure insurance is paying and it's not just going to you. Can you provide us with this? Yes, absolutely. And I will tell you as a broker, right, this only happened a handful of times, but if an individual who is not our main contact asks us for copies of insurance policies, we're not going to be able to provide it. We're going to have to go through our main contact to do that. So, it's only happened a handful of times, but you're absolutely right. Ask for it in a non-contentious way. It really is valuable. Some may just provide it to you, others may not, but sometimes if they won't provide it to you, you can at least ask, is it available? Do you purchase it? What are your limits? Who's the primary carrier? Maybe, kind of work back from there. If you can't get your hands on the actual paper, perhaps other valuable information that you can provide,
Yes, I agree with everything that Ruth has said. And I think the time to do it is at the very beginning of representation. Even, or, let's say that they referred it to you, they know you're in the process of getting the retainer agreement signed, and if you have any kind of advanced retainer fee. So, right, the assumption is that's going to take a few days. And if in that time, they're also sending you an undertaking type agreement for your client to sign, before you're signing that agreement, an approach is to make everyone seem like we're all on the same page. We're all trying to maximize coverage. And, you might, I don't know, bluff is the right word, but just, explain that, you've worked with, insurance before, and that it can be helpful if we're all looking at how to maximize the coverage under the policy, because the entity wants that as well. So to the extent that everybody can be on the same page with insurance from the beginning and framing it that way, and it may be easier to get the documents. I have been the counsel for an entity when the counsel for the individual Ds and Os have requested it. You know, in those contexts, the entity has wanted to work in good faith and is hoping maybe the, you know, individual defense counsel might have some ideas, particularly where there are, you know, potential, you know, criminal allegations that have been made, and there are concerns about whether even defense coverage will be triggered. So yes, I would seek those. And it may be that you want to be looking together, of course, at the insurance policy, but then also how do the exclusions or the limitations in the insurance policy dovetail? How can you suggest potentially that they dovetail with the undertakings agreement? How do they dovetail with the indemnification agreement? So those are some of the things that you'll want to be looking at. So some of the basics for D&O coverage, sort of the who, what, and when, you know, is the starting point. The often in the context of D&O insurance, the sort of the first out of the box thought is that it's only intended to cover directors and officers. And it's important to review the policy definitions, because it may be that certain individuals, whether in certain roles or in certain kinds of claims or involving certain kinds of investigations, are covered, whether those definitions are included in the main policy or in any of the endorsements. And then you'll want to be looking at what kind of coverage there is. You're looking at definitions of claim. If it's a public company and you're looking at a government-related securities investigation, or and then the definitions of wrongful act. And again, those definitions can be sort of the standard definition in the main section of the policy, but then you'll want to be looking at how those definitions may be expanded or limited or amended in the endorsements. And to note is that those definitions can be different for individual directors and officers, sometimes as opposed to an entity. So the you or coverage counsel will be looking at whether those definitions apply to, sometimes it will say not to side C or to side C only or side A only. So those are some of the things that you'll want to be looking at in the sort of basic principles and core of the D&O policy.
And we've talked a bit about this on the last slide. I just want to add one more point about how important side A coverage is. A typical side A policy only will have 2 exclusions. When I say, I mean it. This is just, it is really meant to be very, very broad. It is, it's hard to, we'll talk about trigger, but it's hard. It may be hard to get coverage. I mean, it may be hard to trigger it because it's a very broad coverage and there's many other things you have to kind of exhaust first before you get to it. But if you get to it, it is really meant to protect that individual D&O. So I cannot stress enough that it's worth probing, especially when you have an individual where the corporation is not, paying on its behalf. This is where it's really time to look at that policy. And I don't want to go into it too much, but there's the 2 exclusions you'll see is kind of a fraud exclusion and a bodily injury exclusion. Occasionally you'll see a few others, especially if it's a private not-for-profit. We're starting to see sexual assault and molestation exclusions slip onto policies, but even then it's certainly not the full gamut of exclusions that you typically see. So side A, very valuable when you have an individual. So.
And a practice tip to follow on to Ruth's comments is that the limitations in side A, particularly because exclusions, because the coverage is broader than entity coverage, that's the kind of language that you may want to be looking at to see if you can negotiate language into that in the undertakings agreement. So you want to be looking at that as well as the side B coverage, so that, you know, ideally at the goal would be that the corporation is not stopping its indemnification before the insurance company may potentially stop covering the entity that's paying for the defense costs. So trying to make those align to the extent that it's feasible on the front end are all considerations.
Yeah. And I thought it was interesting because I was not familiar with undertaking agreements before our call with Lisa. And I can assure you, I think Arden and I both agree that insurance coverage is probably generally broader than what you're getting offered in your scope of indemnity under an undertaking agreement. So keep that in mind. And to the extent you can tailor it, do that. I have never seen an insurance carrier yet try to argue that somehow their coverage is limited by an undertaking agreement. At some point, I'm sure they'll try, but hopefully they won't be successful. So anyway, I want to spend a little bit of time talking about what we promised to talk about, which was investigation coverage. We talked a lot about individuals. Investigation coverage for entities generally is much, much more limited under a D&O policy, whether it's a publicly traded company or a private company. Why is that? It's just because there's companies get named in a lot of investigations, and the insurance would probably cost a lot more money if it was triggered at a much earlier date. And often, you know, some investigations are very expensive. Some never lead to the more, you know, the actual proceeding or the formal lawsuit. But for private companies, you definitely want to look, because private company coverage is generally broader in general for an entity than it is for a publicly traded company. So always worth taking a quick perusal if the entity is being investigated to see if there may be any coverage out there. As mentioned at the beginning, I focus a lot on healthcare. And for my private not-for-profit clients in the D&O space, there is typically some very limited coverage for False Claims Act, Stark, and anti-kickback violations in a D&O policy. We could talk, you know, very limited coverage. There are some standalone broader policies available, and not many clients buy them in the private not-for-profit space for those type of claims. But once again, you know, you're going to be the hero if you tell your clients and you find some money for them. So it's really worth asking, once again, where we started, ask about insurance. Is any insurance involved? For public company, it's much, much more narrow coverage, right? It's got to be a securities claim. Typically, a informal investigation or investigation will not trigger coverage for an entity, but I always want to put that qualifier, read that policy. It's a contract. You never know what that contract actually says. And, you know, for some of our very largest clients, sometimes we can really push the envelope and get a little bit broader coverage out of some of those carriers. So it's worth looking at.
Ruth, in terms of advising clients, I mean, I mean, a lot of times I think when those of us on this call are involved in a case, it's probably too late to try to go back and get more insurance. But to the extent that we are advising a corporate client in terms of what insurance, you know, maybe they've been through, you've gotten them through a white collar matter and it's been resolved and now they're looking ahead. Could you talk a little bit about what, you know, kind of what the considerations are with coverage moving forward, you know, especially where a company has already had perhaps a blemish on its record?
Absolutely. So, and that's all, you're spot on. That's where I actually, in the healthcare space, I don't want to spend too much time, but we have something called a government billing errors and omissions product that provides kind of robust coverage for False Claims Act, Stark, and anti-kickback. It's a, you know, basically it picks up where the D&O says, we don't want to cover this. There is a coverage product for it. I would say for entity, when you're looking for investigation coverage, especially, you know, for entity or individual, you're probably looking at kind of more unique insurance products that are typically more expensive. They're more tailored. So you can even get, for a D&O policy, you can buy entity investigation coverage. Very expensive. The coverage can be very narrow. When I say very narrow, some of the things that, you know, some carriers will only offer what they call look back coverage. And what does that mean? It means that only if there's a subsequent capital C claim, usually a securities action, that arises out of that investigation coverage will they go back and pay for some of that cost that they incurred for the investigation. That's just one example. Some will pick it up when you have an earlier stage of the investigation, but it's you need to go talk to a broker and explore what's out there. But there are some coverages. I've actually had a couple clients who bought entity coverage for investigations, and it's the very reason that you mentioned, because they've already been through the situation where they paid a lot of money and there was no insurance involved. So they wanted to explore options. But, in the last couple of years with COVID, we haven't seen any clients we see a lot of reduced budgets, but we're starting to see clients, kind of finances are getting better again. And we're starting to explore again, hey, how do I transfer this risk instead of keeping it on my balance sheet? So to your point, I would say, talk to your broker, figure out exactly what it is you want. Sometimes it can be a tweak of the policy language, but probably more often than not, it's probably going to involve something more significant than that.
Got it. And even with investigation coverage, and even with additional exclusions, it may be, I've had circumstances where clients successfully, under their D&O policy, were able to get coverage triggered after some advocacy and negotiation and pushing on it. We're able to get coverage triggered for defense costs for an investigation. And then in the subsequent, the renewals, or sometimes you will have an insurer will no longer agree to cover an entity. So the client goes back out to the marketplace and looks for another policy, and there may be new or additional exclusions. But again, it's so important to read both that language and then how those dovetail with entity investigation. What I found in particularly with clients that I work entities who are private, and I often will represent clients in the defense contractor space or in the nonprofit NGO, INGO space, and the entity coverage can be great. And in fact, carriers, sort of immediately pick it up more readily, but there can be low sublimits to those. And that's important to consider as well. How much is the cost of adding entity coverage going to be worth it if the limits are 200 or 250,000? Not that particularly for an individual, not that that is in any way, a small amount, but usually we're talking about entities seeking the coverage. And so all of those are going to be factors. And not going to go through the definitions, but these are summaries of the kinds of phrasing that goes into the definition of claim. And these words can be so important. I just want to highlight, for example, the non-monetary or injunctive relief. Right, there's a government inquiry letter that comes. Is that just a notice that they're doing an investigation, or are there allegations of wrongdoing contained within that? How is it framed, and does that trigger coverage? That's an issue that I work with entities in particular, but again, that may spill over into the side B coverage and what the company is willing to indemnify an individual as well. Likewise, the definition of wrongful act, again, seems, sort of obvious at first glance, but often the definition of wrongful act can be a place where there may effectively be coverage. I had a matter where in the 100 and whatever page policy and endorsements, we couldn't get coverage triggered, but in the added endorsement definition of wrongful act, they included in there something, a subpoena or any government document or communication that was the functional equivalent of a subpoena, and we ended up getting coverage triggered. So, hundreds of thousands, over $1 million later, that it's so important to read that language.
And we definitely want to spend a little bit of time on this. We've talked about this, right? Requesting insurance documents. So, and we've hit on the second issue, but I think it's worth actually exploring a little bit more about retainer of counsel, approval of billing rates. You know, I would also say that Marsh, you know, once we get done fighting about the timeliness of notice, probably the biggest issue that we address for our all management liability is the rates for counsel. You know, we tell our clients all the time, to the extent you can, if you have go-to counsel, please get them pre-approved and added to insurance policies. You know, that's a tip I give attorneys all the time. If you have that great relationship, see what they can do. You know, pre-negotiate the rates, pre-negotiate that approval, because it just, you know, it means and puts the ability for our clients to start collecting dollars that they're spending much earlier, right? You've used the firm, they've been pre-approved, you've hired them, you know, you've gone through a lot of steps that you could spend many weeks trying to negotiate and hammer out with a carrier. You've addressed all that at the outset. And I will also add, I have clients where we have 12 to 20 attorneys listed, different law firms listed. So I'm not saying that obviously you all want your own, but you know, if your client even says, we've already got one or two, you know, say, well, you know, think about adding as well. Don't stop there. But I would say, you know, as a broker, every single time I raise this issue with my client, is there anybody that you want us to add? And I will list who's currently on the policy, or if they don't have anyone, I will say, you don't have anyone, you know, let's think about that. Once again, my goal as a broker is trying to remove those friction points with the insurers and get access to the insurance dollars as soon as possible. So I can't stress that enough. If you are in a rate dispute because you haven't been pre-approved, you know, this actually is a good time, perhaps maybe if your insurer is working with your clients working with the broker, talk to the broker. The broker will sometimes know what kind of rates the carrier is approved for within that geographic area for similar law firms. You know, talk to your other fellow folks in your law firm, or if you have friends, you know, if you have friends at other law firms, hey, what kind of, you know, what has the carrier agreed kind of a range to pay you? That can be a very powerful negotiating tactic to get over that. As Arden mentioned, we'll pay you $185 an hour, partner with 25 years of experience in this very complex area. You know, but the rates, you know, there is no simple, we can always solve for it. You know, these are some tips that will help you perhaps get over that and help your client negotiate that. You know, I've also had attorneys, I've said, look, you know, we're getting a lot of pushback. Can you kind of basically sell yourself, you know, go beyond your CV, explain your experience, your expertise. If you make it, you know, if you make that case, it's harder and harder for the carrier to say, no, the rate's not reasonable, or they're not the right person.
And Ruth, we have I just received a question via text message, so I'm going to relay it to the group. In terms of getting information from the broker, for lawyers representing individuals, I think you referenced earlier, you know, your advice to clients is, you know, don't share your policy with anyone. And if you're beyond the point of trying to work collaboratively, and, you know, we're all on the same page, can you share the terms of the policy? Is there a right or any type of, you know, what should be the process in trying to get information about the coverage, or in trying to get information from the broker? You know, what rights do D&Os have, and what's the best approach if you're trying to get that information and for whatever reason the company counsel is not forthcoming?
I'm going to start it with that. You know, good question. So, you know, and I want Arden to weigh in on this one. Rights are tough. You know, if you're an insured under the policy, you all have rights under the policy, right? You may not have rights vis-a-vis the broker, but you may have direct rights with respect to the carrier. As a broker, I have a contract, you know, an engagement letter with, you know, the entity, the named insured. So you're probably not going to make a lot of headway with the broker. I'm just going to be perfectly frank. I would flip it to my, you know, legal department, and from there, you know, they would work with our insured, and, you know, probably, I don't know if that would be successful, but, you know, I think you have a harder time if you truly are an insured under the carrier's policy, for them to say. That was kind of why my advice at the beginning, if you can't get the contract, can you find out the names of the carriers, right? And do you know, and I say this, you're like, oh, it's going to be obvious, but do you know who the named insured under the policy is? Because it's not always obvious, especially if you're like dealing with private equity, right? It's probably some holding company that nobody in the right mind would ever think would be the name. But with that kind of stuff, insurers have obligations. And honestly, my advice probably would be talk to a coverage attorney like Arden.
Yeah.
But she's going to be better at navigating and trying to figure out, and maybe writing that really firm letter back to the corporation saying, your individual client's entitled to this information. You need to give it to us, because if they're not willing to do it voluntarily, you really do need that information. And if you have rights under that policy, then you have rights under that policy. So that's kind of my advice, Arden.
Yes, I would say that this is the kind of situation where if the corporate entity says outright, no, we're not giving you anything, it's the kind of situation where they're sort of taking advantage of you not understanding that your client is likely and insured under the policy. And they're working not with the insurance company, they're working with Ruth, their broker. And so their broker is saying, nope, don't give it to anybody. That's her job, because her client is the entity. So I've not been in a situation where I've not been able to get a copy of the policy when I've gotten involved. Nobody wants to get involved in a dispute when an insured under the policy is asking for a copy of it. So it seems likely that ultimately you can get it, but it's sort of knowing the right questions to ask and asking for the right documents. So, and I wanted to just go back briefly to the point Ruth had talked about, the retainer of counsel and the approval of rates. This is, and she used the term, this could take a few weeks, which I laugh at, only because it almost always, when it's going to be contentious, with the insurance company, that's who you're negotiating with on the rates, it's almost always at least a few months. And the tricky part is the dynamic that the defense lawyer has with its client. Are they going to demand to get paid while they're waiting for the insurance company to step in, or are they going to hold it and wait? And I typically, when I represent private company entities, they will kind of, they'll wait. Sometimes they'll pay, sometimes they won't, because everybody's trying to see if we can get the rate worked out. I've had it take up to a year and a half, but that, I think one in particular, it was a situation where there was a denial. We got the coverage decision switched, so then there was going to be coverage, and they were offering $185, and we ended up getting over $800 an hour. It took a year and a half. It was really hard and the law firm held they didn't demand payment from the company, which is obviously really tough over a year and a half. So there's never really a right answer with that, but it's important to be looking at that and to not, like Ruth said, gathering the kinds of information that show, just like you do any submission to a court on the reasonableness of rates. It's a similar type of approach. Related to that, let's just say the insurance company agrees to counsel, the insurance company got the rates agreement, and now things are moving forward, and now they're writing down the bills and how to deal with that. So sort of some basic tips are here. Number one, in order to make it more likely than not that the bills or most of the bills will be paid, then make your entries specific, not just summary judgment 2.0, summary judgment 2.0. I mean, that's the kind of thing that they're not going to, you're likely going to get a write down, as opposed to research, whatever the issue is, legal issue, and really be accurate with your time. Block billing is a trigger in many insurance company review systems. There's a lot of, in the insurance world, there's a lot of 1.2 and 0.3 and 0.1, and it's more time consuming for the billing to be done, but it is important. Similarly, you want to show if there's two partners on a matter, because sometimes the approval of rates is also done at the same time as the approval of counsel and the approval of positions. And so you'll want to really focus on showing how, you know, senior partner is only doing the strategy and junior partner is in charge of writing, you know, the briefs or, you know, whatever it is. So you'll want to be very specific with that. And then lastly, if there are write downs and they're hefty write downs, which can happen, I would really consider, even if you're going through the corporation, so you're dealing with side B coverage where the entity is paying you and maybe there's a, who knows how this can play out, but maybe somehow there's a write down and they get involved with that as well. You want to push back on a write down where you can justify, which usually you can, about what you did. So all of those things you want to be thinking about with your billing.
Those are all very good points. You know, we've got 5 minutes left. Should we hit a couple?
So I think we can continue past noon, and then, you know, obviously it's recorded. So for people who have to drop off, completely understand, and they can watch the remainder. But I know we've got a couple important slides left and certainly don't want to miss those. There is, we do have a question, Arden, just going back to what you said. In terms of billing, and I know this is I've actually also had this issue of how to deal with confidentiality and privilege issues within billing entries, and, you know, obviously to provide as much information as possible to the insurer, but at the same time, you know, protecting client confidences. Could you address that a little bit, and, you know, whether there's a way, if the insurer is pushing back or, you know, asking for large write-offs or more specificity, if there's a way, you know, how you deal with that in terms of trying to preserve the confidentiality, but yet provide more information?
So I will often, depends on the circumstances, enter into a confidentiality agreement over the content of the invoices before we submit it. And again, this goes to the lag time between the billing, right? You got all of those things that have to be agreed upon. But I've one circumstance where it took 3 months to get the insurance company to enter into that agreement, and it just was so painful for the law firm, is the one that was waiting on payment. But that's something that you want to be careful with. And I would say that it might be a circumstance by circumstance kind of evaluation in terms of how your dynamic is with the entity. Are they asking, how is that working? And so you'll just want to evaluate that to do whatever you need to do to protect your client. Of course, everybody wants insurance to cover, but insurance can't be there. I mean, as a result, you don't want to, jeopardize your client. So it's, balancing those as well. Ruth, did you want to say anything else to that?
Yeah, I mean, honestly, it's a similar issue that Marsh faces, because we are not an attorney, right? And so we will be asked to actually enter into joint defense agreements, being kind of retained by a counsel occasionally. It doesn't happen very often because, generally our position is please don't share privileged information. We don't need it. Confidential information is different. Privilege, we certainly don't, and selective redactions, right? But yeah, I mean, if you send in a bill where you've redacted 3/4 of it, you're never gonna, the reality is you're not gonna get paid. You're gonna have to find a solution. So at the outset, if you can think about what it is you really need to protect as privilege versus just taking the easy, I'm just gonna redact it all and just send it in, right? think about what it really is and try to prevent that, because otherwise you're going to spend time and it's going to be months later. You're doing the appeal process. You're not going to remember, it's just going to add unpaid time to the time you're trying to get paid for. So, but it's really and I will say this, insurance companies look at these issues all the time, right? This is everyone raises these issues with them. There are ways to find solutions,
And I've never had a circumstance where we did not find a solution that worked for the client. The insurance, especially in the D&O arena, they know why there's coverage.
Right.
Ruth made a statement I wanted to follow up on. It's an excellent point. So someone like Ruth, a great broker, is invaluable. That being said, they are not your lawyer. And it happens all the time. And it doesn't matter the sophistication of the client or the lawyer, where they are reaching out to the broker and really sharing privileged information because they feel like the broker is their advocate. And a large sophisticated broker like Marsh does have fantastic claims advocates who can be advocating for payment of claims. That being said, you want to really keep in mind each time, is this something that I would tell somebody other than my lawyer with confidential, privileged protections? And if it's not, then you don't want to be sharing that with your broker. As wonderful as Ruth is, you just want to be really careful with that. Ruth, do you want to talk about notice a little bit? I know we're going over, but and
we just got one more time. We got another question. Does the insurance pay for the time it takes? Really, basically, I think, to determine whether there's insurance involved. That would unfortunately be no. They will not pay for the insurance, your time, or for an insurance coverage attorney for the most part, to determine if there is coverage. So that would be that would be redacted. That would be stricken from the bill, and you probably would not have much success of getting that.
Well, and in fact, it's a double cost, because if you include the time spent to speak to a Levy about how to strategize to get insurance, which happens, I have to then spend the time to redact your invoices, because we don't want to be, now that's our privileged, information. So if you have any questions about how to do your billing in the context of that, you should be coordinating with coverage counsel, but that is not, very sadly, that is not recoverable. But I always say it can often be a small outlay for getting most of the defense costs covered, which is, not that anybody wants to be spending more money, but it can be have a significant impact. Ruth, do you want to talk a little bit about notice? We touched on it.
We have. I mean, my advice is don't worry about the nuances of notice. Notify the carrier. If you have questions, if your client's big enough, they're an entity, the broker will help you. If there's any questions about whether something actually triggers coverage, the broker can help you. I don't want to get too far into the weeds of claim versus circumstance, but there's even a process under a policy where if something's not capital C claim, doesn't meet that definition, you can still notify the carrier. You put the flag in the policy, and if that event becomes the capital C claim, you've put you've kind of started the process of having the insurer on notice. You don't get covered for the cost you're spending, but there's other benefits of doing that. But I would say, early and often is my advice with notice.
And this is where that, right, the knock at the door is so often. Matters come to me months after the first email, phone call, request, even sometimes a year after documents have already been provided. And there are times, oftentimes, when, because it is properly a circumstance that triggers coverage, where we can get coverage triggered, but the defense costs for that have been incurred prior to notice will not be covered. So it's so important. And if you are counsel for an individual, as opposed to the entity, because often this is really the issue that the entity is facing that should be giving notice. This is the kind of topic that you can reach out to the entity point of contact to make it right, make it feel like we're all on the same page. And, you know, has notice already been provided of this? My client received a phone call and retained me, and we need to give the insurance company notice. They may not be thinking about it because they may only be thinking about notice for themselves when it turns into, you know, something real, you know. So that's something that you want to be thinking about as well.
Yeah, and
there's,
oh yeah, sorry, Arden.
go ahead.
I work with some of the largest companies, and they have large, sometimes legal departments, and they are not thinking about insurance. So I think they would appreciate the reminder.
Yeah. And going back to a point that you both made a little while ago, that Ruth, you're not their lawyer. Could you talk a little bit about, you know, often the calls or whatever the initial issue is in these type of white collar cases is extremely sensitive, and the company, if it's just starting an investigation, may, you know, obviously will not have a full handle on what's going on. It, you know, could be a legal issue, could be not. And so what's your guidance in terms of, if you do have an extremely sensitive issue, how you give notice with, you know, without betraying any of the, you know, the confidences that we discussed earlier?
So unfortunately, we face that somewhat frequently, but yeah, pretty frequently. Not the first time. So at that point in time, really, you call the notice, label it highly confidential, right? Once again, don't put privileged information. Confidential is different than privileged, right?
Right.
Highly confidential. When you send it to the broker, you let them know, you keep the notice. Like I've done it where only person that's been given notice is me, and I'm the, and I'm the only, and then I just go ahead and notify the insurance carrier. Unfortunately, I have to also log it in the Marsh system for our own E&O protections, but it's, we are used to doing that. It is it's just making sure that everyone knows it's highly confidential, because I can tell you, I'm doing notice on a daily basis, and, they just kind of flow through. So when you call something like that out, it can be protected. In the insurance carriers, once again, they're used to getting these type of things as well. Right. So,
and this is where coverage counsel can help, where sometimes I will get a call early when there's a very sensitive matter, and we frame the notice letter, with the critical things that need to go into the notice letter to trigger coverage, but devoid of, any specifics.
Got it. That's
so
helpful.
There's in the slides, there's some cases on notice. If you need a little bedtime reading, but just really highlight the importance of timely notice and the complexity in investigations, particularly where, so for example, there's a knock at the door, or there's a letter, and later on, and then there's let's say that arises out of a key tam complaint that's been filed under seal, and a year or so or more, the key tam is unsealed, and now the entity or someone learns of it, even though they were receiving other indicators that something was going on. That's the kind of circumstance where the insurance company would find that this is related back to a prior claim that should have been noticed, and thus it would not be covered under this policy period. It should have, would have, could have been covered under a past policy period. For D&O claims, they must be triggered, and they must be reported in the same 1 year, usually it's 1 year policy period. And this relates also to, in the context of, for example, mergers and acquisitions, which can be complex because there's other kinds of coverages too that may come into play, but where there's a clear dividing line on the acquisition date, where some investigation is related to facts that may have occurred before the current policy. So all of those are going to be factors to be looking at, and you'll want to be considering those right away in terms of, and maybe need to consult with coverage counsel so that you're thinking about it in the way that's going to position yourself best for coverage.
Yeah, I've only got a few more minutes. I do have another event I have to prepare for, but I would want, one thing I definitely want to add is we've talked pretty much exclusively about directors and officers insurance, and this is kind of towards the end, but one point I would absolutely want to make, to me, is very critical, is there are many other types of insurance that could potentially respond both to just the capital, various claims, as well as investigations. And we've listed a few here. Within the E&O realm, there's a lot, the errors and omissions realm, there's a lot. There's, if you're a health insurer, there's managed care insurance. There, if you're in the financial side, there could be investment advisor, there could be banking errors and omissions insurance. There could be a lot of investigation coverages in those various policies. Employment practices liability. I actually have a very large client who has a government False Claims Act, right? They're publicly traded, would never be covered under the D&O, but this particular False Claims Act matter was brought by a whistleblower who is now alleging retaliation. If you have that retaliation claim with your False Claims Act, guess what? Employment practices liability insurance could come in. Is it going to pay 100%? Likely not, but it's still paying probably a very large portion of something that's not typically covered. And so think about things like that. Fiduciary insurance, that could be a department investigation. There's just other coverages out there. And, my tip here is if there's a broker, ask the broker, hey, what else are we buying? Should we be notifying with respect to this? Because that's our job to help identify other things.
And I would say that conversation, just having come in a little bit after the fact, that the brokers can be very helpful early on in terms of deciding which policies to give notice under. So as you're trying to figure out, what's going on, and also in the context of, particularly with private equity and where there's changes in ownership, rep and warranties in some circumstances may be able to provide coverage even if there is no entity investigation coverage. One other point, I know Ruth is gonna has another something that she will need to get off for soon, but is the certain key exclusions. So these are just some of the typical exclusions that come up in the context of D&O. A critical thing to remember is that defense coverage is broader than indemnification coverage. So that means the likelihood of getting coverage trigger to pay for defense costs is greater than the likelihood of getting the insurance company to agree to cover a settlement. And so it may be that many of these exclusions are included in an initial reservation of rights letter, but that isn't, while it's something that you or coverage counsel will want to be looking at and maybe be pushing back on in a reply letter, at the same time, these exclusions may be listed only because the insurance company has to list all of the ways in which it might exclude coverage to protect its own rights. So they're going to throw in the kitchen sink if the kitchen sink is potentially related in any way. One of the exclusions that comes up, and this I think sort of comes up in the conduct exclusion, which is the one at the top listed there. Sometimes it's a fraud exclusion. There's different variations on that, but in many policies, and I'm thinking particularly in the private entity coverage space where you may be able to secure defense coverage successfully, the point at which coverage may terminate based on this type of exclusion may not be until there is a final adjudication, past the trial phase and at the appellate phase. And that is a consideration, in our discussion yesterday, talking about the undertakings agreements, which has such a broad and quick cutoff for indemnification of the individual by the entity. It may be that language from the conduct exclusion section of the policy can be borrowed to make it, match up, at least, try to negotiate for something like that. And the practice tip at the bottom, which is an important one, is not all and often many exclusions do not have this label as exclusions. It's an issue that is litigated in the insurance coverage arena, whether language that excludes coverage is an exclusion, because the insurance company has the burden to prove an exclusion, whereas the insured only has the burden to prove that there is coverage. And so this becomes important in a variety of contexts. But what it means is that same lesson that that when I first moved to private practice and started doing insurance coverage, was that every word in a policy and all its endorsements matter, and you want to be reading them closely and carefully.
And Ruth, I know you need to go.
I definitely got to sign off. So
Thank you
I
very
appreciate
much. And Ruth's contact information, we're going to post the PowerPoint, as we said, on the forum library. And so Ruth's contact information is there. Thank you so much, Ruth. This has been great. And Arden, if you have time to stick around and go through this final slide.
Yeah.
I apologize for the multiple commitments. Thank you.
Oh, no.
Bye. Thanks.
Thank you.
Bye.
Bye.
So the last slide is just kind of some of these key points, key things to be thinking about early and often, thinking about your insurance analysis, but certainly early on to evaluate whether there are any issues and how to surmount them in order to, secure defense coverage, be able to secure the defense counsel that you want to secure as defense counsel, because that's often where I get my referrals, right? I can be the defense counsel's best friend in helping the client secure coverage, which covers the defense counsel costs, and frankly makes the whole relationship often, better, because there's a stream of money that's coming in that's paying those defense costs, and ideally as close as possible to the rates that are being charged. Timely notice of claims, and the last point, the voluntary settlements without insurer approval. This is an issue that typically entities will face more than individuals, but where there is coverage or notice is late, whatever the circumstances, and a policyholder, an insured, decides to enter into a settlement payment of some kind without coordinating with the insurance company, and simply by virtue of having settlement discussions without involving the insurance company, that's the kind of act that could exclude coverage that might otherwise possibly be there. So lots of things to think about, I know, today. Thank you to those who stayed awake during this. I can stick around if there are any other questions. I'm not sure how long folks want to stay on.
Arden, I'm not seeing any other questions, but I think that was a very, very information-packed hour and 18 minutes. So thanks again to both you and Ruth. And I think at the end of this, all of us, the one thing we do know is if we get ourselves into a sticky insurance situation, we know who to call.
Well, thank you so much for inviting us and letting us talk about this. And best of luck, everyone.
Thanks so much.
Bye.
Bye.